We thought it'd be best to offer this up. So this session will be video recorded and put up on Karetsu TV for all of our members to be able to view. My name is Brianna McDonald. I'm the president for Karetsu Forum Northwest, and I thank you all for joining me here in the room today. As we embark on 2020, one of our core focuses this year is corporate governance and how we can leverage the investment community here at Karetsu Forum to be able to vie for those board seats. We do see common practices in the VC world, things that they've done very well is being able to get on boards and help drive liquidity. This is something as investors that we're very focused on as well. So how we can, even though we're working individually, somehow create some processes and procedures to work together for those board seats, and then really getting back to the fundamentals of what corporate governance is, the formation of board of directors. The conversation in the Academy today will focus on the bare bone basics of what this is and how it operates, and then throughout the year, the Academies will then build off of this session that we are in today. So know that this is our goal. Last year we spent quite a bit of time on term sheets and focusing on those, thanks to our help from our corporate counsel here, Carney Badley-Spellman, so thank you for coming back and helping us with this effort. From those term sheet academies and really the investors banding together, we created some new protocols and procedures for our companies around term sheets, around looking at the term sheets and about being able to make sure that it's a good balance for not only the entrepreneurs but the investors coming in and signing those term sheets. So we created term sheet committee where we'll be reviewing the deals that have been invited to our organization, and that's a small group of individuals working together on that. So we are excited about the opportunity of what's going to come from this education around corporate governance. Really quick before I'm going to pass the meeting along to others is I would like to just go through a quick 15-second introduction. Who you are, how long you've been a member, and your core business and what you do. Real quick so we can get an idea for who's in the room. For those of us joining online, just please bear with us here as we do this, and then we'll finish up with the Carney team, and they can introduce themselves and then move forward into the presentation. So Jeff, we're going to go ahead and get started with you.
My name is Jeff Barnes. I'm the CEO of Angel Investors Network. I also manage a small angel fund, Angel and Heroes Venture Growth Fund, as well as just started up a private equity fund as well that we're filling up.
And how long have you been a member, Jeff?
I have been a member for about 4 months now, 4 or 5 months.
All right, welcome. All right, Elaine.
My name is Elaine Chen. I've been a member of Karetsu for a year, almost exactly. And my background is in B2B cloud software.
All right, great.
Michael Stein, I've been a Karetsu member for 7 or 8 years. I'm an attorney and an investor.
All right.
I'm Andrew Holman. I'll split the difference. I've been a member about 3 years, and I'm starting a biotech company, and I'm a rheumatologist.
All right.
Kelly Charlton, my background is consulting in financial services, and I'm a member for about 4 months.
Stephen Sperry, I'm a prospective member, repeat founder with background in building technology companies, venture-funded technology companies.
John Marrow, this is my first meeting, so thank you for the invite. I work for a principal of One Accord, which is a consultancy company, and ex-CEO, so thank you for inviting me.
All right, great, welcome. Just be sure to speak up. There is a microphone at the middle of the table there so the people online can hear you.
Molly Shore. I'm a community partner from E8, which is a clean tech angel investment group. I have a background in engineering and an MBA, and I'm also impact committee chair for Karetsu.
Great, welcome, Molly.
Gary Ritten, I've been a member about 10 years. Wear a couple of hats, day jobs, investment banking, president of Puget Sound Venture Club, another one of the angel groups in town. I should mention that Mr. Sperry a few years ago had the best deal we've ever had so far.
All right.
That's more than a few
More than a
years.
few years ago.
All right,
Generous. Yeah.
welcome Gary. Evan, welcome.
Hi, Evan Shea. I'm a guest here today. Thanks for the opportunity. My background is more finance side, been an angel investor for about 2 years.
All right, great, welcome, Evan.
I'm Siram. I'm from most recently AWS. I'm a founder and angel investor for a few smaller companies in Los Angeles and here in Seattle.
All right, welcome.
Thanks.
I've been with Gerritsen for about 2 years. I'm an angel investor as well as I myself. And I've been a number of startup companies. I'm just starting a new company, so just right time to learn about this again.
All right, welcome, Aki. Mark?
My name is Mark Perry. I'm a guest today, and I recently retired from the information technology market. I worked at Microsoft for 25 years, so I've been retired for now 2 months, and I'm trying to figure out what life is after being in a large organization.
All right, great, well, welcome. We'll go back to, we'll start with Mark, and we'll kind of move it on.
You just stand up and do it.
Stand up and talk loud so they can
do
hear
5
you.
things at once. Let's see. Okay, so what's the
What's your name,
What's my
what do
name?
you do,
I got that
and
one.
how long you been a member? That's it.
what's it? Oh, okay, good. Easy.
Super easy.
Super easy. Okay, so Mark Gerard. I have a company, Stage Right Ventures, and do investment valuation work and M&A transaction work. And how long I've been a member? I don't know. You tell me. How long I've been a member?
2 years.
What's that?
2 years.
2 years. I've been around them way too long.
You've been around us much longer.
Much longer than that. You know, so I've been around all this for a long time.
All right.
So.
Awesome. Welcome, Mark. Eric?
Yeah, thanks.
Eric Mandel, been a member about almost a year now, doing angel investing and that background in cloud computing and technology.
Welcome. And?
Hi, Joaquin Gallardo. I'm a sponsor of Karen through Wells Fargo Bank. So I work with a technology banking group at the early stage, and I'm here to help and support.
All right, well, thanks for coming today. Appreciate you being here. And then who is running the show today of the 3 of you?
Well, I don't know. We'll all hand it off.
Well, I'm just
but-
trying to
but
figure
I
out
can-
which way to introduce you so it
Go to
ends.
Joe.
Okay, we'll start with Joe. So Joe?
I'm Joe Wallen. I'm a corporate attorney here in Seattle. These are my colleagues Bryant Smick and Danny Neuman. And we're a firm called Carty Badley and Spellman, and we do a lot of work with early stage companies and investors in early stage companies. So I'm pleased to be here today and talk to you a little bit about boards.
All right,
Yeah.
awesome.
Well, we're happy to be here. I'm Danny. Corporate securities attorneys. It's fun being able to see it from both sides of the deal. We probably most of the time represent the companies and help them put the boards together, and obviously interface with the board a lot. Also represents the venture funds and investor groups. So that's great as well.
So meeting logistics for the 3 of you. The voice recorders are here in the middle of the table, so please project for the people that are joining us via the web. And with that, I will give the clicker
Sure.
to you, Danny, and I will put this into presentation mode and start the recording. Thank you for everyone joining us online. And like I said, this will be also up and available on Keiretsu TV probably by mid next week.
Great.
Awesome. Well, we're here to talk about boards and corporate governance and some of the details of that. We'll start with the basics, some of the mechanics, how you get on a board, how it's put together, and then move into a little more nitty-gritty, what the duties are, some pitfalls and liabilities that directors can face personally. It's something that's getting a little more attention, especially in light of things like WeWork and that debacle and what the oversight was there. So it's really good to kind of go back to basics and understand, what are the duties and what investors, when they do take a board seat, how they can exercise some oversight, and certainly how to negotiate for a board seat, and put a really good experienced person in place that can, exert some guidance on the founding team. Is there another? All right. That's awesome. Okay, so
There's a guy from Microsoft.
Harvard. Yeah, that's perfect. So this is a really good book. It's the Corporate Directors Guidebook put out by the American Bar Association. So if you're on a board or you're thinking about being on a board, it's definitely something to flip through. It's pretty slim, so you know, good bedtime reading.
Yeah, you can buy this on Amazon for about $45, and it's a great book. And so if you have any questions about, you know, being on a board and what it means to be on a board, this is a really nice thing to buy yourself, or maybe with credits you can buy a bunch of them and hand them out or something. But it's a good guide if you're looking for some basic, well-written for non-lawyer person sort of guide.
Yeah. Here, let's. Yeah.
Does it matter what state you're in, or?
No, it's written as a global, as a kind of a national plain
US,
English book.
not
Yeah.
Europe. Okay.
No, it's a US
Oh
book.
yeah, definitely U.S. I mean, it talks about federal like SEC securities rules and laws and things like that. So yeah, we can talk about some of the basics, maybe speed through it because you guys are all probably familiar enough with it. But yeah, the board of directors is the management governing body that exercises rights and considers the big picture, certainly. And they elect and appoint the officers to run the day-to-day. And typically boards meet quarterly, usually companies after their first bigger financing round, whether it's from an institutional, and you get an outside investor or an independent board member, that's often the time that it really comes together, where it's just the founding team on the board, the other institutional directors come together and put the structure in place. Yeah, the shareholders elect the board, and the board's the one that elects the officers. Yeah, the fiduciary duties down there at the bottom, duty of loyalty, duty of care, and we can talk about what that means a little more in detail later. Yeah, so just some of the mechanics. The incorporator is kind of just a nominal title. They appoint the board once the company's first incorporated, then the board grows from there. We like to just do everything by written consent. The shareholders, they're ones that obviously elect everyone, but you don't need to have an actual meeting in order to do so.
Yeah, usually if you're appointed to a board, the board itself will expand the size of the board and then appoint you to fill the vacancy. That's usually the procedural mechanism to appoint someone to the board. Shareholder meetings are, especially in private companies, not typically something that happen every year. What you have with the corporate statutes is you have statutes which say, oh, you're supposed to have an annual meeting. And then you have the statute go on to say, well, if you don't have an annual meeting, it doesn't affect any of the corporate action. And the worst thing that can happen is a shareholder can demand you have a meeting, in which case you can have one by written consent. And so, technically, you just don't see private companies frequently having formal shareholder meetings very often anymore. Public companies have to have them, but private companies typically don't frequently have them, don't have them every year. That doesn't mean, as a matter of governance or good practice, it's not a good idea to have meetings at which shareholders can ask and have their questions answered. But those could be informal meetings where there's no formal action taken. But the formal action, electing the directors, is taken by written consent, and the informal part of the meeting is a Q&A which you invite people or have a conference call. So, in any event, just some nuance there.
Yeah, definitely. And I should definitely mention, let's keep this as conversational as possible. I mean, some of this is some basics, so we want to talk about what you guys want to talk about and questions and situations you've seen. So that's probably some of the most interesting stuff, is that nuance.
I got a question.
Yeah.
So, I'm seeing a lot of startups where either they don't have a board or there's one person on the floor who's the founder of the company. Is that essentially the same as not having a board? And
No, that's a board. Every corporation has to, under law, have a board of directors. It can't be one person. That is the
How long
board.
can a company operate with one person on the board?
Could be forever. Could be forever. I mean, there is a signal there from an investor's point of view. And we've seen, some big companies fail that had, allegedly poor governance, probably in fact poor governance. And there are studies done in public companies which look at public company performance over time and try to, ascertain whether performance is related to the quality of governance. And I think the general prevailing point of view is that better governance equals better performance over time for companies. I think that's the general prevailing point of view. I think that partly answers your question. I mean, I think as an investor in a company, you would like to see, whether it's you on the board or other representatives of your investment group on the board, you would like to see some governance structure that that's not just the founder, him or herself, on the board. And as a practical matter, founders themselves should also want some board structure that allows them to do things like have their salaries approved. We're going to get into this a little bit later, but if you have a one-person board and you're the CEO, what protection do you have from a fiduciary point of view if you're paying yourself a few $100,000 a year? I mean, how do you protect yourself from a claim that you're not breaching your fiduciary duty or duty of loyalty by overpaying yourself? If you have a well-constituted board with independent members who can approve your salary, then you've protected yourself as the CEO. But we're going to get into that a little bit later. But technically, all these corporations have boards. They have to under law. But it might just be one person.
Right.
So I have 3 questions, and I'm going to ask them in an order, and hopefully which you can answer it and it makes sense. So when should a board start meeting? I mean, because we're looking at these companies for investment opportunities, and just like Joe stated, my understanding of a board of directors is they do have a fiduciary responsibility to the investors, for their investment. And there's certain insurance and things that comes into place with that. So when should we start looking at at these investments to see that they're actually meeting and there's some sort of a board in place, even if they're early stage? And then, what constitutes a correct board at the different levels of growth? So just the life cycle of the company, you have the ideation stage where, you form the company and you have this idea, you probably have, founders on the board, but as you start bringing in outside investment, what should that growth process look like? And so we can really coach the companies that we're working with to have some good practices there. And then who are those people that are supposed to be there? So yes, some of them could be shareholders, but there's also talk of having just an independent board member of someone who has startup experience and has exited a company that can kind of hold the shareholders in check with what's going on. And then, I don't understand the election process, so maybe you could
Yeah.
do that.
Yeah,
I'll lead off on
definitely.
that one. So I think, kind of just to dovetail off of what Joe said initially, if you're a one-person board, I mean, I don't think anyone really cares to know that you've met with yourself and you've discussed and thought about these things, right? But at a certain point, you're going to bring on additional board members, and a lot of times I think that's going to be when you do bring on outside money or something like that. And I think as an investor, when you're looking back to see is the board been operating the way that it should be operating, I mean, the diligence that you're performing on your end is making sure that presumably there's big corporate action that's occurred that should have the approval board. Issuing safes, taking on debt, doing a number of things.
Probably a dirty word around here.
It is a dirty word.
It
is a dirty, yeah.
Convertible notes.
Yeah.
So anyways, yeah, I mean, there's a number of things that presumably should have board approval, and your initial kind of stage of diligence when you're doing your investment is making sure, all right, did they do their board consents to issue options to employees? And that's how you can look and see if the board has been operating efficiently and correctly from the outset. Once you come on as an investor or an independent board member, comes on the scene, at that point, you would imagine that there should be, regular meetings of the board of directors to discuss things beyond just corporate actions. There's a lot of avenues in board meetings to use that time to talk about the state of the business and where it's going and talk about strategy. And, once you start having third parties in there and the board starts to grow, I mean, that's when you start thinking about having those actual meetings.
Yeah, and a lot of times One second, I'll go. A lot of times, yeah, so when the first money does come in, like your first fixed price round, outside of convertible notes, is when the lead investor will usually negotiate for a board seat. It may not happen, but that's usually something that I would put on your checklist when you're investing to make sure that whether it's, whether Keiretsu has invested enough to like be the lead investor and can appoint someone, or whether everyone tags along with some other institutional investor and make sure that that institutional investor is going to put someone on the board.
Observers to.
Yeah.
Yeah.
Yeah, but go ahead.
Yeah, kind of to link into both of those questions is like,
Project.
and Brianna's question, sorry, do we go
Yeah.
all the way? It's
project
like
out
a
of
big arc over
Yeah.
to the speaker here. So to link into those questions, what requirements does the board have to report certain things to the shareholders? So again, from kind of linking to what you were saying, like you pay yourself $200,000 a year for money you raise that you're putting money in, and I've seen boards that I'm like, wait, there's a clear problem here where nobody on the board has real skin in the game, and all they're doing is sort of saying like, yeah, well, great, we need to spend more money because we got to get there. Meanwhile, they're not getting there, and then they're not reporting this to the shareholders, but they're now doing a new convertible round, note round, and so I think that's a real problematic, because if the board is able to sort of authorize something, but is not required to report this to the shareholders, then they can just raise money at will without any oversight and kind of going that. So what requirements, I mean, I guess we have to put them in the corporate documents and make those requirements.
Yeah, in a private company, there are very few things that actually have to be reported to the shareholders. And so if you're going to make an investment in the company, you want to make sure you get a steady stream of information from the company. You're going to want information rights. You're going to want information rights requiring the company to contractually send you the quarterly financial statements. Under Washington's corporate statute, corporations are required to give the annual financial statements to the shareholders, but that is a often overlooked, unobserved obligation. But in terms of like, if you don't have the information rights or any kind of contractual rights to information, there's very few things that actually have to be reported to the shareholders. So if you want that information, you're going to have to contractually bargain for it.
Yeah, presumably the board of directors it's a little bit like voting for your state representative or your senator or something like that. Like your board members are people that you're elected to represent your interests at the board level. So presumably they're the ones that are handling those things. There's not a reverse flow of information that's required by statute.
But the board doesn't represent your interests as like a certain segment of the shareholder group, whether Series C, Series A, whatever. The board has to look out for the best interest of the entire company. That's what the fiduciary duties are. So the shareholders,
The entire company or all shareholders?
yeah, in the best interest of the shareholders.
All shareholders.
All shareholders, no matter what stage that they're at.
Yeah, not just a constituency.
But I mean, I guess my question, just a clarification, does the board have a fiduciary duty to the shareholders? Yes. But do they also have a fiduciary duty to, say, the CEO and other employees to sort of balance the interests of everybody, or are they looking out for shareholders?
Their duties to the shareholders.
Unless you're in Germany. Europeans is very different.
Yeah, sure. Yeah, in the U.S.,
We're the UK.
yeah, in the U.S., if you're a regular for-profit U.S. corporation, your duties to the stockholders to maximize value to the stockholders. You can form, in Washington State, you can form a thing called a social purpose corporation if you want. In California, there's a thing called a flexible purpose corporation. Delaware calls it a public benefit corporation. Basically, these are corporations where the fiduciary duty has been altered in the state statute so that your duty is not to simply maximize returns for shareholders, but to also consider other, potentially socially impactful things like worker welfare. And these statutes sort of arose out of what transpired with the Ben & Jerry's ice cream company. I don't know if you all know that story, but when Ben & Jerry's went to go sell itself and hire an investment banker, it came down to two bidders. One was Unilever, and there was, who offered the most, and then there was a second bidder who offered quite a bit less. And that second bidder who offered quite a bit less had a social, cultural, it had a better social cultural fit. But the lawyers for the Ben & Jerry's company told the board, well, you can't sell that company to the lower bidder. Your job is to maximize the return to stockholders. And as a result of that, the Ben & Jerry's founders went to the legislature in their state, and these creatures, these social purpose corporations and these other benefit corporations came into being. Of course, if you're a stockholder and an investor in a company, you'd probably prefer the old model. You'd want to see shareholder value maximized. You certainly wouldn't want to see half the proceeds from the sale, paid to the clean up the Puget Sound or something. Probably, I'm guessing. Maybe it depends on your point of view when you make the investment. Yeah.
Thank you, Andrew. At the next.
Well, you just did all the work on the term sheets. So all my term sheets clearly spell out the rights of the investors for information. We had common round, and we actually then upgraded the common rights to preferred rights, so they would actually get all those things, just because it seemed like the right thing to do, even though the lawyers were kind of scratching their head. So it seems like in the term sheets and so forth, all that should be in there.
Yeah, totally agree.
Well, so the nice thing is, Andrew, is that you are also an investor, so you understand what we're looking for.
I'm not taking advantage of somebody else.
What we're looking for here. But some of these things, and we're not gonna dig into term sheets too much today, but they're convertible notes. So if you did negotiate the information rights into a convertible note, when it converts, your contract is then converted.
Right.
And so those information rights don't stay. So a side letter would be something that you would utilize instead.
Yeah, sorry, there was another question back here.
Oh, just really quickly, are there any tax benefits or, other kinds of benefits besides psychological benefits to having a benefit corporation?
Oh, yeah. So a social purpose corporation it's a regular Washington for-profit corporation. So it's no different from your typical for-profit corporation, except that you have this potential fiduciary allowance for directors to consider other things other than just maximizing shareholder value. So there's no sort of tax-exempt charitable nonprofit tax benefits there. These are still corporations that pay taxes in the ordinary way.
All right, back to boards.
Yeah. Good. So we kind of already have touched on a lot of this, but
yeah, one of the mistakes, I'll speak to this a little bit. One of the mistakes I've seen in the past, I haven't seen it for a long time. If you want to assure yourself of a board seat, it's not enough that the company signed a contract with you saying, we'll appoint you to the board, because the company doesn't appoint the board members. The shareholders elect the board members. And so if you want to assure yourself of a board seat, you've got to have an agreement executed by shareholders in which they agree to vote their shares to elect who you designate or who you name as the person who's going to be elected to the board.
So with that, so if there's a certain amount of, on average, the last couple of years, Keiretsu Forum in the Northwest puts about $700,000 in on average. So with that, I'm just trying to think through my mind process here, but if we were able to band those investors together that all came in on a deal and said, okay, well we would like to elect so-and-so to be the representative on the board, then that would be a way that we could mitigate that to help make sure with the investment that we put in that we get a board seat.
Yeah, and you just want to embody that in a shareholder or a voting agreement that the majority of the shareholders sign.
Well, what if it was take the valuation and the 700,000 is like 10%, you want 10% of the shares? How do you still get representation?
You get the majority of the shareholders to sign a contract saying they're going to vote their shares.
People, you have to track that.
Yeah,
you make the founders, you make the other investors, you would want option holders who exercise and usually get above 1% of the shares to also become a party to that voting agreement, which is sort of like a living document. So anytime a new shareholder comes on board, usually the company will make them as a condition of owning the shares, sign that agreement as well. So you as a 10% holder, or collectively as a group owning 10%, are entitled to do that, and all the other shareholders have to vote for you for about one director seat.
So how does that work when you are at the seed round and the majority shareholder is the founder?
You get the founder to sign the agreement.
So technically it is coming from the company then, right?
No, he's signing it in his capacity as a shareholder.
Yeah.
So he has to sign as chairman. Yeah, chairman of the board.
No,
Signs
no,
as a
no,
shareholder.
as a
He
shareholder.
signs as shareholder, right.
Because the shareholders are the one that elect each director seat. And the golden rules, like how do you get him to do it? You say, I'm not gonna give you the money unless you give me a board seat.
Right.
So
Well, I think that's where I'm getting confused on this part, because the founder is the company in the early stages.
Right, but you're contracting with the shareholder as an
Right.
individual person, not the company as an entity, so that's the kind of distinct difference there.
Yeah, and you can look, I mean, the voting agreement will be signed by all the shareholders. The company will also sign it as well, but it's the shareholders who vote the shares to elect the directors. So the company's obligations in the voting agreement are basically things like, use commercially reasonable efforts to fulfill the purposes of this agreement. But it's the shareholders who elect the directors, not the company. So you gotta have the shareholders sign their capacity as shareholders and commit themselves to vote in that way, or execute consents.
Well, then going forward, if you said earlier that the other directors will then say, okay, well, you're bringing in this round, you're 10%, for example, and the directors are acting in capacity of representatives of the shareholders, can the other directors then just say, we're gonna create this board seat without direct consent from all shareholders?
Yeah, if you have a board and they want to appoint someone to be on the board would typically resolve to increase the size of the board from 5 to 6 people, and then they could appoint someone to fill the vacancy. So you don't have to go through the contraption of a shareholder vote. But if you want to assure yourself contractually of a board seat, you've got to have the shareholders sign a voting agreement.
And the other key provision in a voting agreement is usually what is the size of the board. So maybe after, say, raising $1 million in a Series C preferred round, the board will go from, say, 1 or 2 founders to 3 people, where the founders get 2 and the investors get 1, and then all the shareholders sign it, and they'll agree that you can't increase the size of the board to 4 or 5 or 6 without the consent of the new preferred stockholders. So.
Good question. So, what do you guys think of insisting on D&O insurance being in place?
Super smart. I probably wouldn't be on a board unless the company could get D&O insurance. I would make sure you went to a good broker and you got insurance that had all the things that you wanted in it. So yeah, and usually you can get like $1 million in coverage for I think around $5,000. The person I usually refer people to, the insurance broker I like, is a guy named Mark Ganley at AH&T Insurance, and he's been doing tech company insurance. Ganley, Ganley, and we could shoot right his name and number after the meeting if you like. Good person, been doing this for 20+ years or something. I'm sure they're really great insurance.
Max Chavaria, if Kiretsu does it.
Okay. Yeah, but D&O insurance, very smart. Most, venture funds, if they take a board seat, they'll require.
So you have to actually look at it. It's not like it's all standard.
You just want to, my caution is just make sure you have a good broker and you're getting the coverages that you desire and the amounts that are customary and typical.
What would be customary for a startup?
Well, I frequently see like $1 million in coverage for smaller rounds, and then as the rounds get bigger, the coverage amounts expand.
Yeah, I see like 1 to 3 is fairly standard. Yeah.
So would you recommend that a prospective board member read the policy?
No, I don't think you're gonna, in all honesty, these are pretty hard to read documents. And I don't think as a layperson you're probably gonna make much headway in reading the policy, but I think if you're coming onto a board, it'd be fair for you to talk to the broker to make sure you got the coverages you want, or if the company's counsel has been engaged to help review the policy to make sure it provides you all the coverages you want, you can talk to the company's counsel.
Yeah. And in your investment documentation, a lot of times there will be a provision there saying like you're going to obtain D&O insurance and then policy amount up to $3 million or something like that. So usually you're covered in a couple different ways.
How would you know what coverages you want?
Talk to the broker.
Okay.
Talk to the broker.
Are you mostly liable for the amount of money that was invested might be lost, or liable for potential future earnings if the company is run well? Well, how's the court look at it?
In my experience, what the D&O insurance is going to cover are things such as, Well, it's actually not, it's not an area in which I'm really well versed. But, it's not necessarily gonna cover investor losses. It's gonna cover liabilities, like
For some of these things.
failure to, I mean, potentially allegations of fraud against the company, potentially, depending on whether the companies, took actions and acted consistent with the policy such that they'd be entitled to that coverage.
Negligence, that kind of stuff.
It's not gonna cover, a D&O policy is not gonna cover claims for unpaid wages. So this is one of the things we're gonna talk about in a little bit, but I guess maybe right now, but you can get, along with your D&O insurance and your general commercial liability insurance, you can get employee practices liability insurance coverage, which would cover things like claims of sexual harassment or wrongful termination.
I'm sure you need that.
It's helpful, it's helpful.
Maybe I could,
Yeah.
I'll throw a hypothetical at it,
Okay.
because I think it'd be up Andrew's alley. It's kind of part of what I'm thinking, trying to figure out what role the board really has. I've heard people say, well, the board doesn't want to micromanage the CEO. But let's say it's a medical startup. Lots of money invested, there's a lengthy FDA approval process. Let's say somewhere in there, the company screws up on the FDA process. They do something wrong, it gets denied, goes bust. Somebody points the finger and says, the board, you guys were supposed to supervise that. Is the board liable for that?
The board is entitled, and this is written in the statutes, the board's entitled to rely upon the advice of experts, outside counsel, outside accountants, outside professionals. And if the board had hired a law firm or a consulting firm to manage the FDA process, and the board believed that that firm was giving good advice, I don't believe that'd be a circumstance in which the board would be liable. If there
Let's
was
say the CEO though hired them. Let's say the board didn't hire, is it the same?
Same. CEO's entitled to rely upon outside persons.
There's a big issue between governance and management. Boards
Right.
are for governance and not for management.
Yeah.
That was my question, where do you draw that funny little line?
Right. Yeah, well, in the sense of this hiring of a firm to assist with the FDA process, I mean, I think the board would be well advised to make sure that the firm that was hired had a good reputation, had handled similar things in the past, was, had good references and appeared to be competent to handle the matter. I think that would be a good and advisable thing to do, especially if it's a mission critical function of the company.
So
And you
some
can fire the CEO.
Board can fire the CEO.
So
Yeah.
that's your leverage.
Right.
So I think to that point, something that'll give some good context here is the business judgment rule. And I mean, here is a quotation for you guys so you can actually see how it's defined by the Legal Information Institute. But the kind of core thing to remember is, as a board member, like you have a duty of loyalty, you have a duty to like not get conflicted out or enter into conflicted interest transactions. But your decisions and what you do in the performance of the company isn't necessarily something that, provided that you're not doing anything wrong or fraudulent or negligent or anything horrible, you're protected. I mean, the idea is the board is here to try to make the best decisions they can, but they're protected by this thing called the business judgment rule that says that if you're making a sound decision, you're relying on advisors that knew what they were talking about, and it just so happens that you didn't get the business outcome you wanted. That's something you're protected against as a board member of the business.
It's really deferential to the board. There's a presumption that if the board got sued by a shareholder, let's say, the shareholders would have to overcome the presumption that they acted according to
This is really why you want to minute these minute, have lawyers present or have somebody who's competent taking minutes. Minute these deliberations and your thought processes on matters such as this. There was that case a few years ago, you might have followed in the news, where the Disney company wound up paying Michael Ovitz a very, very large severance amount, $80 million. It might have been several $100 million, I don't know. But it turns out that the board only talked about it for like 10 minutes, and they didn't even see the employment contract. And it came up kind of in passing at a meeting. And it looked from the record that they had acted very precipitously. And to be entitled to the business judgment, well, you've got to act on an informed basis and in good faith. And you've got to act as, I mean, this general standard of care for a director is you've got to act in a prudent manner, like a reasonable person in a similar situation would act. That's the general standard. And so you want to, if you're making significant business decisions, like potentially obligating a company to pay a CEO who doesn't work out $80 million in severance, you want to document that you've done some careful thinking about it.
I'm sure you get into board compensation because we're all interested in that.
Yeah.
A lot of money. So part of that is that there are some companies in town who have just some really famous boards that just sort of back the CEO and did all kinds of sort of Ponzi scheme stuff. Maybe you can explain that. That's a conflict of interest. So we really think we have to raise money, but $50,000 a month is a lot for a board member, right? So,
oh, for sure.
So
yeah.
And then the question is, well, do we want to keep their board seat, or do they want to do the right thing? Anyway, you could speak to that, maybe.
Well,
I don't know if we're going to pay an board member.
Yeah, in terms of well, it's a decent question. Like in terms of compensation arrangements, so we're gonna get to this in a little bit. But if there is a conflicted transaction, so the CEO's compensation or board member compensation, these are, if the CEO is on the board, these are what are referred to as directors' conflicting interest transactions. These are transactions in which a director has a conflict, and there's a couple different ways to sanitize those arrangements. The most common way is to have two independent directors review and approve the matter after full disclosure of all the material facts. If you do that, then shareholders can't make a claim that you've acted inappropriately. If you have a board that's one board member and it's the CEO and the founder, and he or she is going to pay themselves something that might be considered out of market and above market salary, the way to sanitize that would be to go to shareholders, the independent shareholders, and get holders of the majority of the shares held by independent shareholders approve the matter after disclosure of all the material facts. So there's just some ways to sanitize or protect yourself in those situations.
Yeah, sorry to keep interrupted, but so to build on that,
yeah,
it's easy to say with Michael Ovitz where you have a sizable board and they have a publicly traded company. Yes, it might not look very good to have 80 million, but if we have, if one of our companies raises $1 million and they decide to pay half of that to the board and the CEO and founder who's hasn't actually had approvals and like, oh, we had somebody else look at it, which was his co-founder. It's sort of like we're almost like not talking apples to apples here. We're like, and so I think that's probably central in my mind is like, how do we protect these boards when these people are raising $1 million and there's so much chance for fraud and so much chance for like, oh, we didn't have, we missed the market, or there's, the business, I see it, business judgment rule, like, yeah, but they all have bad judgment when they're starting to do the startup. So we're trying to see like, what's the best way to sort of both protect the board and the company and investors? Because like you say, go to the shareholders. Well, what if there's only 5 shareholders? Like, go to who?
Yeah, well, if you're the investors, you can build into your investment documents that the CEO's salary will be increased without the approval of at least 2 independent directors.
And that's one way to do it.
I mean, that'd be a way to do it.
So you just sort of add in kind of some controls at the early phase, but maybe not too many like you would have Disney.
Yeah, I mean, public companies aren't necessarily great, examples because they have a lot of structure built into them that we simply don't want. But you do see companies like we're doing the finance area right now, where we're going to empower the compensation committee, which is going to be comprised of, solely independent directors. They're going to be the party that's solely responsible for setting, executive officer compensation. And so you do see situations like that, but it tends to be more mature private companies than these really nascent ones. But if you're investing in a Series C financing, you can simply build into the documents that, hey, the CEO's compensation is not going to be increased without independent director approval, if you want.
Yeah, I like that.
Yeah, so compensation, whether it's salary or stock options. So that's definitely something to put on your checklist and make sure that you consider when you're making an investment.
That's good.
Yeah, and what you were saying, like, oh, if they raise $1 million and then they make their salaries $500,000. I mean, the duty of care, I'd probably say, what's market? Has the board done its diligence to figure out what's market? And that probably doesn't sound reasonable, because you're trying to grow and hire other people to expand the
Yeah,
company.
you could also, I mean, as an investor, you could also specify the use of proceeds of the fund. So you don't see it all the time, but you could specify, hey, we're gonna fund this coming to $1 million and here's how the money's gonna be spent. Require the covenant, require the company to covenant that it's going to spend those funds in a certain way. Yeah, so as far as like, we covered this a little bit, let's go back a slide, the, sort of, you can resign from the board at any time. It's just, you can resign by simply submitting a written resignation to the board, saying I hereby resign, effective immediately, date it and sign it, it's super simple. Oddly enough, to be appointed to the board, you don't necessarily have to sign anything, but the rest of the board has to, by resolution, resolve to appoint you, or you need a shareholder vote. Let's keep going through the other examples here.
This is good intelligence to, just as a technical point, make sure you know the lineage of the board, and make sure you have a proper resignation that you show later on.
Yeah, what you want is, and some companies are sloppy about this, but sometimes somebody will send an email in, I hereby resign or whatever. I mean, it's not really ideal. You want your, if you're investing in a company, you want your company to have a minute book that is put together correctly. And you don't stuff your minute book with a bunch of emails. You stuff your minute book with, properly executed corporate documents so that when you get to your bigger financings and you get your, bigger law firms who are very particular about how they want things presented, looking at the corporate books, they don't have anything to complain about. You really want to make that, hopefully that Series B and that Series C financings just go smoothly as possible because you document everything along the way in a nice looking way. So it's, yeah, go ahead.
I have my attorneys do the minute book, they keep track of everything.
Good stuff. You
should
be safe. You should be safe.
Oh,
Your
that's what
attorneys
everybody did, they're happy to charge you.
They love that. I mean, it's like, oh, we'll do this great startup kit for you, and we'll charge you for the minute book, and it's great.
It's good. It's smart to spend a little bit of money along the way on lawyers. I mean, I'm sometimes also an investor in companies, and I appreciate the point of view of, hey, we don't want to spend unnecessary money on lawyers. At the same time, that's not wise, but we do want to spend enough that we have everything looking as good as possible, so we set ourselves up for success. But it shouldn't cost very much money.
So, along those lines, it seems to me there's probably software for like keeping board minutes and making sure it's on your calendar and maybe keeping the books. Is there any software you could recommend that?
I think there may be some, actually, I think there is some software in the marketplace, but when I minute meetings, I just use Word minute meetings. Not hard to use Word minute meetings.
Would you do a Zoom meeting and just record it?
I wouldn't recommend recording. No, I'd recommend just
too good of a minutes that way.
Yeah, I mean, you might provide too much grist.
Summary. You don't want to have to like go back and watch a 4-hour board meeting or something.
Minutes should be fairly abbreviated. I mean, they should, and I could send template minutes around to everyone here if you'd like. They should just reflect, hey, when the meeting ended, when it started, when it ended, who was there, you had a quorum present, you gave notice, and then, the various things that were, show the board was doing its job were discussed. And so you don't have to say, hey, so-and-so, raised the question about, this or that, but you can recite, hey, we talked about the financial performance of the company, we reviewed the financial performance of the company, we reviewed its cash position, we looked at its remaining available runway of funds. I mean, you just recite kind of the general topics of what's been discussed, and that just shows you're doing your job, you're paying attention to what's going on.
So it's basically the agenda for the meeting without, you don't have to actually type what was said.
No, you're not going to want to type what was said, but you're going to want to write down the topics discussed. Right. And potentially how much time was spent on a particular topic if it was an important topic.
Yeah. If there was actual approval that was taken, yeah. Like issuing shares or options or whatever.
In the Disney case, they probably would have been better off not saying how much time.
Well, the minutes reflected they spent like 10 minutes and they didn't even review the draft employment agreements. Those were good facts.
Right.
Let's keep going.
Is there term limits for boards?
No.
Not like nonprofit boards or other things like that?
No. I mean, you could put them in place. You could say, hey, there's going to be a 3-year term or like a staggered term for if there's
Is
5
that
people.
quite common? Or there's
No.
also-
No, I just was
In more
curious.
mature companies, there might be that, but
Not newer
no,
companies. Okay.
yeah,
Right.
and probably not necessarily recommended.
Yeah.
Not, I mean,
Yeah.
it just adds too much nuance and complexity.
Yeah, okay,
Yeah,
perfect,
yeah.
thank you.
Let's keep going. These are the two primary fiduciary duties of board members, duty of loyalty, duty of care. We talked about the duty of care. This is to act in a prudent way, in a similar way as a reasonable person in the same circumstance would act. The duty of loyalty is basically an obligation to act in the best interest of the corporation and not the individual director's best interest.
Right, like, I think in WeWork, that was an example where the CEO, he owned a bunch of real estate, and then he had the company take out a lease with his, so that's a conflict of interest and should be disclosed, and everyone approved it,
Although,
make sure
although
it's
for all we
great.
know,
You could.
SoftBank's directors approved all those things.
Yeah,
I think the complaint I heard about this, about WeWork, was really that SoftBank was sort of smoking its own supply, is what I heard described as, meaning instead of bringing on new investors who could bring a fresh, viewpoint on what was going on, it just kept reinvesting itself. And there was no real, independent source of governance in the company. That's the complaint I heard about that company. And you do hear that complaint about companies in Seattle from time to time as well. It's like, hey, there's no real governance in that company. There's no real independent people, typically more than one, who are really watching what's going on and trying to make sure things are done correctly. So these are some of the summaries of what these duties are. And it's pretty easy to, like I said, that ABA book is a great guide. And it's pretty easy to find this information online if you're curious about it. The big things I would watch out for, let's keep going. If I'm a director, one of the most common things I see is this concept of not paying employees wages to which they've been promised. So in Washington State, there's a statute designed to protect employees, and it says, hey, if you told an employee you're going to pay them $100,000 a year, and then you didn't pay them $100,000 a year, and maybe you entered into a quote-unquote deferral arrangement as the company was running out of money, this is a disaster. Never enter into a quote-unquote deferral arrangement. This means you're admitting you owe this person the money, and if you somehow never get the money to pay them, then you've admitted you owe them the money, and under the statute, they're not only entitled to the money you owe them, they're entitled to 2 times more the money you owe them, plus their attorney's fees and interest. And this adds up fast. Like if you have a company that hires somebody, calls them an employee, and doesn't pay them correctly, and 6 or 9 months or years go by, you're talking about more than $100,000 potentially in liability, and this is a potential liability personally of directors. So you can be a director, and maybe you promise the CEO or somebody a severance, the company's runway gets short, the company runs out of money, you can't pay the severance, now you're getting sued personally in a lawsuit by this person. These are not fun lawsuits to be a part of. So the answer is, if you're running out of money, you're running out of runway, and you need people to agree to work for less than you agreed to pay them, what you do is you have them sign a salary reduction agreement. So not a deferral agreement, a salary reduction agreement. Everyone agrees, hey, I'm going to work for, I know you said you're going to pay me $100,000 a year, I'm willing to work for minimum wage today. And I'm willing to work for minimum wage for as long as I decide to work for minimum wage. I'm an outlaw worker. And then you build into that agreement, that salary reduction agreement, basically a bonus, which says, hey, if we raise $2 million in equity financing in the next 12 months, we'll make a bonus payment to you to make it up to you. That way, if you don't raise the money, you don't hit the milestone, you don't owe the money, and there's no lawsuit in which you're personally named. So don't do these deferral arrangements. They're insane. Don't do them. That's a liability you don't want to expose yourself to.
And one other thing that comes up is an earlier stage company, they'll bring someone on, like maybe and they'll call them the CTO, or they'll even appoint them, the board will appoint them as the chief technical officer. And by definition in Washington, if you're an officer, you're an employee, and if you just grant that person, give them, say, 10, 15, something like that, % equity, you're like, oh, well, they're just working for sweat equity like the other majority founder, but they're not drawing a salary. And sometimes there's these co-founder divorce cases where they have a falling out, and that CTO person comes back and then makes a wage claim. And
Yeah, you can hire someone as an independent contractor, but you want them to sign an independent contractor agreement in which they acknowledge they're only working for the stock options. And you want them to otherwise meet the technical requirements of being an independent contractor. You'd prefer, if at all possible, that they have a business license. The state, it always takes the view that if the independent contractor doesn't have a business license, they're not an independent contractor. Now that's not technically the law, but that's the view the state takes. And so, in any event, I mean, don't get involved in situations where you're not paying people minimum wage in cash if they are in fact employees.
Just to clarify, so that, I all the time see startups.
Yeah.
That are, it's all pixie dust, they have a slide deck, and they have people, friends and advisors that aren't getting paid, that are full-time, and they list them as chief technical officer.
Yeah.
You give them these titles that have the word officer.
Yeah.
Are you saying
Well,
that those people would
Well,
have a wage?
I could argue, I think, fairly persuasively, especially if I have the right paper behind me, that hey, the chief technical officer title is not an employee title, it's a job description. It's a job description. But calling someone the CEO, pretty hard to argue the CEO is not an employee. And the IRS has a concept of a statutory employee, and they say, hey, if you're an executive officer, you're by definition an employee. You can't be an independent contractor. But it's just a touchy issue because of the Washington law with the double X damages, the attorney fees, and the potential personal liability, and that's something that your D&O insurance will not cover.
Did you say there was another kind of insurance that covered that?
No, I'm not aware of any insurance that'll cover unpaid wages.
So is there a way you can mitigate this for your investors? So for instance, I'm the CEO, but I don't get paid. Obviously, I don't
Well,
want to get paid.
if you're the dominant founder of the company, you're not going to sue yourself.
Right, but I don't want people coming on thinking I'm going to try to pull a fast one down the road or something.
Right.
I'd like to have a document that says, do I release that claim?
Yeah, you
Is
can
that
execute such a
possible?
document.
If they're going to do it anyway. I'm not asking for back wages.
Usually you're mostly worried about like the minority co-founder. It's usually the minority co-founder who
Be my wife.
sues you.
But
But it's pretty
everything's
common.
half.
Yeah, it's pretty common for a majority founder to not pay themselves a salary. I mean, it's certainly idiotic to start a company, dump in after-tax money, or money you've already paid taxes on, and then run it through payroll again. That's idiotic. Who does that? That's insane. But with the minority co-founders, it can expose you to a risk.
Is
I mean,
co-founder an executive title?
No.
That's not a legal title at all. People call themselves, hey, I'm the co-founder and the CTO, or the co-founder and the CEO.
Right, so co-founder.
Whatever. But it doesn't actually mean anything.
So we're going for an hour, right?
Yeah,
Sorry.
well, we saved an hour and then a half an hour for Q&A.
Okay.
But, we've been kind of,
Good question.
Okay.
And there's a question
Yeah.
back there.
Andrew answered, I was gonna ask his scenario, so he answered.
All right, let's keep going.
Yeah.
Okay, so there are situations where you have heightened duties. We talked about the conflict of interest transactions already, and we touched on the sale of the company transaction concept already too in the context of the Ben & Jerry's ice cream company. But yeah, in the context of a sale of a company, the classic scenario is you've got a great startup going, you're making progress, and then all of a sudden out of the blue, someone approaches you and says, hey, here's a term sheet, we'll buy your company for $20 million. And maybe you invest a couple $1 million, and maybe you think, wow, that's a great deal. $20 million, we should take it. You can't just take it. You can't just take it. You have a duty in that instance to essentially run an auction-like process to make sure you're getting a reasonable amount for the company. And so this is called the Revlon duties. I mean, I see people shaking their heads. You've got to go through some process to make sure you're not, because how do you know? Maybe 20 million is too low. Maybe you sell for 20 million, you think it's a great deal, but then you get a bunch of minority shareholders who sue you and say, you screwed up, it was worth 50 million. You owe me $30 million, you botched the job. You've got to document that you went through a process. Maybe you hire a banker. Maybe you hire a banker to do a market check. I mean, you can be put in situations which are kind of uncomfortable because maybe 20 million is a great price and you really don't want to run a process because you don't want to lose that offer. So these are sensitive situations. You want to have good counsel involved. Yeah.
So the, how's that, me?
You.
Go ahead.
Okay, so yes, along those lines, and so then part of this rather fun situation where, there's a lot of dilution. So you start having these fun little board things going on, and they're, oh, hey, well, we need more money, and then they're not really saying anything, or you don't know what other raises they got going on. People in California really like to do that, and so, not that they want this to be better than Californians, but there's so many deals that go through there, and there's a lot of money raising, and so what I've seen happen with this is that then there's this dilution, and then it's like, will you guys accept this now? And then you're like, you know, I mean, there starts to look like a real, like, how, what are the protections